Hi, everybody. My name is Neha. Thank you for joining us today. I'm currently a second semester law student counselor in the Detkin Intellectual Property Clinic, supervised by my professor, Cynthia Dahl, who has joined us here today. I have been studying intellectual property throughout law school, and I have most recently worked with clients that needed trademark clearance and registration. So I'm very happy here to do a Trademarks 101 session and give a brief overview of the law. Just some disclaimers. This webinar is being recorded and will be published on the Gittes Legal Clinic's website. This is also not legal advice. This is general legal education. And if at any point you think that you want personalized client care, then please wait till the end of the presentation to learn more about how you can apply to be a client in our clinic. Like Jordan said, if you have any questions, please feel free to drop it in the chat box. That chat box will only be seen by the hosts. But please remember that this is not attorney-client privilege and to not post any confidential information that you would not like us to know in the chat box. Other than that, please save all questions until the end where we will do a live Q&A. All right, now to get started, a little agenda for this webinar. We're going to discuss what exactly a trademark is, what it's not. We're going to search on how to pick a strong trademark, how to search for the availability of said trademark, when you should apply for federal registration and what that process entails, and then how to use that mark to build equity and make your business goals come to fruition. All right, so as a basic overview, for those of you that don't know, there are generally 4 tools that counselors use to protect brands and creatives for their work. There are patents, trademarks, copyrights, and trade secrets. I think I said that correctly. I'm sure you've heard a myriad of these types of protections throughout your time, either building a business or creating some type of product. But what we will be focusing on today is a trademark. So what exactly is a trademark? A trademark is a mark that serves as a source for, to create a source recognition for a good or service. So what do I mean by this? Let's take Apple, for example. When I say that I'm going to Apple to buy a phone, you know exactly what I'm buying. I'm buying an iPhone. I'm buying an iPhone from a very reputable brand that has created this goodwill by, making a product that is so subversive in our society that when you hear Apple, you think of the tech company. Likewise, when you see the little logo, the Apple with the bite mark, you also know you're getting a Mac product. That is trademark in action. Now, trademarks can be word marks, logos, designs, and they can even be smells, tastes, colors. Think of the Tiffany & Co. signature blue. When you see that, you immediately think of Tiffany & Co. However, for small businesses, startups, and indie creatives, what you want to focus on is registering and protecting your strongest mark, and that is usually a word mark. A word mark delivers the broadest protection because a word mark can be protected for all the ways it is spelled, all the ways it is pronounced, and generally is the mark that gets infringed upon the most. And so if you're a smaller business and you only can afford to register one mark, try to focus on your word mark if you have one. In the event that you have a logo, just like similarly, if you have a logo that can signify a source, but you want to add a word mark to it, there is a world where you can do your word mark and your logo and make a composite mark. This is a good place to note that if you want to trademark a word mark or logo or slogan, that these are all separate registrations. So each one will have its own fee and you will have to go through the application process for each mark, unless you were doing a composite mark, which would be one application. So to kind of expand on what I was saying earlier, the broader your mark, the broader the coverage, but that might make it harder to get past registration, which is something we'll touch on a little bit later. This is also a good place to note that business names, domains, and company names are all separate protections with separate registrations. Registering for a trademark does not necessarily mean that that domain name is available, and it does not afford you domain protection. If you have a mark that you really like and you have successfully registered it, get the domain name as soon as possible and register it as needed as a proper corporation. If a domain name is currently taken and is being used in good faith, you're out of luck and you should look for a different domain name. However, if there is a domain name that is not in use and there's a bad faith element to it, someone took that domain name knowing you were going to take it, there are anti-cyber squatting laws that you could find some avenues in. But generally, register your mark, get the domain name, and register this business. Now let's shift over to the third point, which is the common law rights versus the federal rights. Common law rights begin as soon as you use your mark in commerce. So a way to tell whether a mark is registered or not is if you see a mark with the little TM or the SM that I'm sure we've all seen on some product somewhere. That means that mark is currently being used in commerce and has common law rights. Common law rights do mean that you can have protections against cases of infringement, and you do get protections in the market in which you're using it. One part about common law is that it is restricted to the area in which you use it. So let's say you're a small bakery in Philadelphia. If you are selling your goods throughout Philly or Pennsylvania, then your mark is protected under common law rights there. If you choose to make this a nationwide chain, you should think about federally registering this mark, which now takes us to federal registration. So marks that have been accepted by the USPTO often have the R, always have the R with the little circle. Federal rights extend, once again, nationally. So if you are a business here in Pennsylvania and you are a federally registered mark and someone is infringing on your right over in California, you have the rights to make a case for infringement. You also have a constructive notice of use on the market, and after 5 years, you become eligible to apply your mark for incontestability, which means that your mark has greater protections with the USPTO office. So now that you know what a trademark is, let's pivot to how to choose a strong mark. There are 3 factors that are important in determining what makes a strong mark. We will discuss distinctiveness next, followed by likelihood of confusion. But while we're on this slide, let me go ahead and let you guys know what a trademark is not. A trademark cannot be other people's names. It can't be a deceptive mark that signals something incorrect to a consumer. And it can't be generic. And we will touch on what generic is in this next slide. So one of the most important concepts in trademark law is distinctiveness. And what I mean by this is it determines whether a mark can be protected, but also how strong that protection can be. We measure this through a scale called the Abercrombie scale here in the legal world. And as you move up the scale, the marks become more creative, you get more protection, and they are more easily protectable. So as promised, we're going to start with why can't we trademark generic terms? So generic terms are words that are the common name for the good or service. They tell you what the product is, not where it comes from. So for example, if you are a company that is selling bread and you have named your company Bread, that won't fly because you have named your brand what the product is. Similarly, naming your brand apples, if you are selling apples, you are simply using a common term that other people in the marketplace need to use to describe their product. So if everyone in the marketplace needs to use it to describe that good, then it's no good. Generic terms are never protectable under US trademark law. Up next on the spectrum is a descriptive term. So descriptive terms mean using marks that describe a quality or a feature of the product. So for example, think of creamy for yogurt, or Holiday Inn, which is a very popular chain of hotels. So Holiday Inn describes what the product is. An inn is a place you stay, it's a hotel. But the reason that this has protection is that it has acquired secondary meaning over time. So what do I mean by secondary meaning? This means that consumers over time have come to associate that mark with the good or service. Descriptive terms are not inherently distinctive. They don't immediately stand out as a consumer source recognition. They have to develop the secondary meaning over time. For new businesses, these marks are hard to protect because you need time and resources to build that secondary meaning in the market. So as a tip of good faith, if you are looking to make a mark that is a stronger mark, try to shy away from descriptive marks as they take time, and oftentimes new businesses just don't have the resources to do so. Next up the scale, we have suggestive marks. Suggestive marks are kind of the sweet spot for entrepreneurs, indie artists, creatives that want legal protection, but also need to use these terms to market their product. They don't directly describe the product, but they do require a bit of imagination to get the consumer to understand what this product could be. So take Netflix, for example. Net makes you think of the internet, flicks make you think of movies. You take a logical leap and you go, okay, this mark has something to do with the internet and television, movies, maybe watching movies on the internet, maybe it's reviewing something. It requires the consumer to make some logical leaps, making it inherently distinctive. These marks are protectable as soon as you begin using them. Next up on the scale, we have arbitrary. So this is when a real word is used out of context. So going back to Apple, Apple has nothing to do with the technology, yet it stands out because it is so out of context that you can easily remember that Apple is the tech brand and that Apple isn't like some apple orchard. And similarly, we have Shell for gas companies. Shell has nothing to do with gas, but it stands out because it is just so arbitrary and it is not in the correct context of what that good and service is. These marks are strong and receive broad protection because they're unexpected and highly recognizable to the consumer. Up at the top, we have the strongest mark you can make, which is a fanciful mark. Fanciful marks are completely made up words that didn't exist in the English dictionary. These terms only recognize the brand itself because they don't actually have meaning in the marketplace. So take Kodak or Exxon or Xerox. These are all made up words that have no real meaning, although they have meaning to us now, specifically to the brands themselves. So these marks are inherently distinctive and the easiest to protect. But for small businesses and new creators, the trade-off here is that it can be kind of hard to market these terms. You want to, create a name and invest in something that is something the consumer can kind of, be attracted to. They might hear Netflix, and then a tech person might say, oh, I can maybe watch a movie there. Whereas for Kodak, they don't really know what they're getting. So that's usually the trade-off. If you are making a fanciful name, you might have to spend more time in research and development and consumer marketing. So to summarize everything I just said, because this is a lot of information about distinctiveness, generic terms are never protectable. Descriptive terms can be protectable if they acquire secondary meaning. Suggestive, arbitrary, and fanciful terms are always protectable and can be and range from lowest to highest in protection, starting from suggestive all the way to fanciful. So now that we've touched on one of the categories that the USPTO will look when reading your application, let's turn to what happens if your mark is distinctive. Then they will evaluate between the marks that are currently in the market and see if there's a likelihood of confusion between your mark and any similar marks. So what this means is this is a test about what the average consumer will think the source origin is for these brands. So let's say that you have a mark for a daycare center named Apple. That mark is identical to Apple, the tech brand, but you're a daycare. It's a service. Apple is in the goods category. So the likelihood for a consumer to think that Apple, the tech company, has opened a daycare center is very low. That likelihood of confusion stays low, and if the USPTO examiner believes that there will be no overlap between consumers, that mark might pass. We look for similarities in both the spelling and the phonetic pronunciation of these marks, and we compare the whole mark to the whole mark. And if there is a composite mark, we'll take the mark that is most significant or most prominent to the mark and compare it to a similar mark. Another thing to look for when determining whether there could be likelihood of confusion with your marks is what goods or services are sold under the mark. So let's say you want to start a business for Jimmy John's, which is a popular Subway sandwich brand, but you want to sell Jimmy John's to sell tractors. If the goods and services are sold under a different market and it doesn't look like there's any overlap in the goods and description services, that mark could happen. similar to the Apple example earlier. All right, so now that we've discussed likelihood of confusion, and let's say you have a mark hypothetically ready to go, what do you do with it? You can search for this mark and see if there are any conflicting marks. So if you go to uspto.gov, you can use the new Trademark Center and search your mark. There are many tools available that can help you filter out marks by goods and services categories, and all federally registered marks will come up in this Trademark Center. Look for identical marks, but also look for variations. If you have if you have a brand called Apple, look for all the ways it could be spelled, look for the phonetic spelling, look for marks that have the word Apple in it, and see if they are in overlapping goods or services. Don't forget to run a quick Google search for your mark as well. Oftentimes, small businesses may not be able to register their mark, but they've been in commerce for a long time, and so they might have common law protections. So once you've started searching, what do you do with this information? Let's say there's a similar mark or an identical mark, and you're trying to figure out whether this mark is worth pursuing. The most important categories to look at here would be, are they in a similar class or industry? And how similar are they in sound and appearance? If you have an identical mark that is in a completely different class and industry and a low likelihood that these consumers will overlap, you could proceed with that mark. Likewise, if you have a mark that is not super similar, if a mark that is similar but is in the exact same class and has overlapping consumers, you could run into problems there. If you proceed to pursue this mark, then you should also take into account what the sophistication of the other mark is, so how long it's been in use, if it's active, it's been recently renewed, and what the current status is. So now that, let's say you have your trademark, you've done the search, and you say that you want to maybe register it, what factors should you consider? So when you're deciding if you should protect a trademark, you want to first discuss, what is your intent? Do you want to use this regionally? If you want to use it only in a state or a city and you have no intent to expand your business, or do you plan to sell this nationally? Are you thinking of using this mark long term? And if so, have you done any considerations for how this mark could expand? If you start off as a snack company and then you want to move into a different related industry, have you accounted for that? Have you done the search for that? The next you want to look is, are you currently using the mark on your good or service? So here, this is important because this will determine what kind of application you will apply for, which we'll touch on later. But if you are not currently using the mark, you want to note that the U.S. operates on a first-to-use system. So even if you have a mark all ready to go and you plan to use it in a year, if a junior mark comes in before you begin using it, that should be taken into consideration. And then depending on the results of your search, again, if there's a similar mark but it isn't registered, this still could be confusing if common law rights in that area have been, if everyone in Philadelphia knows what that mark means, if you come in, there could be a consumer confusion. So something to keep in mind. And so now that we have discussed if you should file the trademark, let's discuss what the application process is. So you can either choose, if this is a good or a service, and depending on your application type, if you can file an intent to use. So like I said, if you had a mark that you think you want to use, but you don't plan to use it for a year, you can file an intent to use, and your mark will stay on a registrar until you are ready to use it. But this will notify the USPTO that mark will be something that you will be applying for. Next, you should choose an international class. And you can either use the description of goods and services that the USPTO drafts for you, or you can draft your own. You should note that it now costs $500 to draft your own description of goods and services if you choose to not use the description that the USPTO already provides. So something to note for smaller businesses if you want to save a bit on resources. Then you must describe the mark, and if it has a logo, you must describe each individual aspect of that logo. And then you have to provide a specimen, and what that means is provide some proof that this mark is in use, whether it's a nutrition label or the website, just some proof that this mark is being used throughout commerce. And then each application for a trademark costs $350. That is the price as of today. That price may change depending on when you file your trademark, but it has been pretty consistent for a while now. So continuing on with the application process, it usually takes about 8 months to hear back from the USPTO. With the government shutdown, that might be extended for who knows how much time, but generally if the government is running smoothly, it'll be about 8 months. Remember that the examining attorney is a human at the end of the day, something to note here as well. So while you might feel really confident and your attorney might feel very confident in filing this trademark, if that human feels like there's a likelihood of confusion or that the description isn't proper, or if there's an indefiniteness, they could send an office action. And an office action is basically explaining why your mark is rejected, and if you choose to pursue it, you can respond. If you respond, you can explain why there isn't a likelihood of confusion and really build your case. You have about 3 months to answer this, and you either receive a second office action and you get some pushback, or the mark proceeds to the publication period. If after the publication period there is no objection, then the mark will proceed to registration. If you filed that mark with an intent to use, you also must file a specimen and pay the registration fee even before the mark proceeds to that registration process. All right, so now that we've kind of discussed trademarks, let's discuss how to use them for your business advantage. We like to call it the 3 M's, which is maintain your mark and monitor it. So maintenance. What I mean by this is financial maintenance. Between the 5th and the 6th year, you have to file a declaration of use affidavit, and this affidavit costs $325, and this basically means that you are still using this trademark and you intend to keep using it. After 5 or 6 years, you also become eligible for a declaration of incontestability. If you are eligible, this basically enhances the legal protections that you have, and this affidavit costs an additional $250 on top of the $325. At about 9 to 10 years of you having this mark must be filed for a declaration of use and an application for renewal. And you must do this every 10 years, and that application costs $650. There is a grace period for if you miss the registration, but after that grace period, if you fail to file your registration, this will result in a cancellation of your mark, and that can't be revived or reinstated. So something to keep in mind. All right, so now that we've discussed the financial maintenance, let's discuss the proper way to use your trademark. So touching on what we discussed earlier, if you are using a mark that is popular in common law rights, you should use the little TM or the SM, or if you have federally registered this mark, make sure to have the R with the circle around it. You can use this trademark for advertising, packaging. You can use it if you are, printing this in a newspaper anywhere. What you can't do is say something like, look at all those apples over there for tech products. You can't use it as a noun, and you can't use it as a possessive form. So, my apple isn't something people usually say. They say my iPhone. They describe the product. You don't usually you never use the trademark as a noun or a verb. And now to discuss monitoring. So this is a bit interesting. The USPTO has both you and the consumer in mind, but because of the vast amount of marks that are registered, it's not productive for them to be policing this mark. So proactive policing is important for the mark holder. So you want to be looking out for unauthorized uses of this mark, for potentially confusing marks that come on the market, or any uses approved by trademark licensees. If you are not actively policing your mark, it will be harder to enforce this trademark against other people. The USPTO here will evaluate marks that are being applied for likelihood of confusion. So they will be on the front end reviewing applications that could be in conflict with your mark, but it is your job to also be monitoring the marks on the market. All right, so now that we're reaching to the end of the presentation, we just wanted to give a little bit of information about the Intellectual Property Clinic. This is the information for our professor and supervisor, Cynthia Dahl. If you have any interest in becoming a client for this clinic, please see this information.